What about you, sir? Do you think the colored students will show up?
If I got anything to do with it, they won't show up. Well, I think it's a breaking point of the school integration. I just don't feel that they have a right to go to school.
In 1896, the Supreme Court decided that racial segregation does not violate the Constitution. In Plessy v. Ferguson, they recognized that the 14th Amendment requires equal protection of the laws, but they held that separate but equal is good enough to satisfy the equal protection requirement. The Supreme Court would eventually change its mind about this, but it was a long and difficult road to get there. One of the key events that got things started down that road occurred in the summer of 1908, when there was a riot in Springfield, Illinois. 2 black men in that city had been arrested. A large crowd of people formed outside the city jail, and they were going to lynch the 2 prisoners. The sheriff managed to sneak the 2 prisoners out the back door to save them, and he had them transferred to a jail in another town. When the crowd realized that the prisoners had escaped being lynched, the crowd got angry and there was a riot. And a lot of homes and businesses were destroyed and some people were killed. The governor of the state had to send in National Guard troops to put a stop to it. These riots got a lot of national attention, in part because Springfield, Illinois was a town in which Abraham Lincoln had practiced law and served in the Illinois state legislature. So there was this tragic irony that so many years after the Civil War, the nation would still be having these racial troubles in President Lincoln's own city. That winter, after the riots, some folks met in New York City and decided to form a new organization. It was the NAACP, the National Association for the Advancement of Colored People. They announced the formation of this new organization on February 12, 1909, on the day that was the 100th anniversary of Abraham Lincoln's birth. So they were clearly trying to connect the new organization to the legacy of President Lincoln. The idea that slavery had been abolished and the 13th and 14th and 15th Amendments had been adopted, but the promise of those things hadn't been completely fulfilled, and the project needed to be finished. The NAACP had lawyers, and they started litigating cases challenging racial segregation. Again, Plessy v. Ferguson was the law of the land, establishing the doctrine that separate but equal is enough to satisfy the Equal Protection Clause. And rather than attacking that doctrine head-on, the NAACP lawyers and others in the civil rights movement decided that it was best to proceed in small steps, progressively or incrementally, a little bit at a time. Baby steps, you might call it. And so they started with cases in which they accepted the principle of separate but equal, and argued that it simply wasn't being enforced. In other words, they found situations where there really was no separate but equal provision of something for African American people. And in particular, they focused on graduate and professional schools. For example, one of the cases was about law schools in Missouri. Missouri didn't have any law school that a black person could attend. The state offered to pay tuition for black students to attend law schools in neighboring states. But a lawsuit was brought to challenge this on the ground that this was not really separate but equal. And the Supreme Court agreed.
There, Charlie argued that segregating states should be required to provide Negroes with equal educational facilities.
The University of Missouri had refused to allow Lloyd Gaines to enter its law school. But they said they'd pay, if necessary, for Mr. Gaines to attend law school in a neighboring state. The Missouri court found that quite a reasonable offer and ruled against Mr. Gaines. Your Honors, If Missouri offers its white citizens a law school, it must also offer its Negro citizens a law school every bit as good. And it can't just miss the problem by saying to Mr. Gaines, now you just run on over to Kansas, Nebraska, or Iowa, and they'll take care of you over there.
In other cases, such as one brought in Texas, the state would actually establish a law school for black students, so at least there was something being provided. But the lawyers would challenge it and say this isn't really equal, even in the most obvious tangible ways, like the facilities and the professors and courses and libraries and so on. It was not equal. And courts agreed. They said, hey, if separate but equal is going to be the rule, then it really does need to be equal. And so the lawyers bringing these cases gradually built up more and more precedent, and more decisions were won that recognized the inequalities of the separate education systems for black and white people under segregation. And eventually, after many years and many cases, this effort led up to Brown versus Board of Education. Linda Brown lived in Topeka, Kansas. She was 7 years old. She attended a public elementary school, and to get there, she would walk 6 blocks to a bus stop, through a railroad switching yard, and then she'd ride a bus, and it took a total of about 80 minutes for her to get to school. Her father was unhappy about this, that she had to travel so far to get to school every day, because there was another public elementary school that was much closer to her house. And so, one day, Mr. Brown walked to that nearby school and tried to enroll his daughter Linda there. But the school rejected her because it was an all-white school. And so Mr. Brown contacted the NAACP, and they brought a lawsuit for him. Eventually, the Brown family's lawsuit was consolidated together with other cases brought in other parts of the country. There were also cases from South Carolina, Virginia, Delaware, and Washington, D.C. The members of the Supreme Court first heard arguments and met to deliberate and vote on these cases in December of 1952. After hearing the oral arguments, the 9 members of the Supreme Court met to conference and talk about the case. And the substance of their meeting was secret at the time, of course, but now we have a general sense of how it went from notes taken by the justices and what they later told biographers or other people.
It's very simple for me. The state cannot classify people by color for education.
I'm with Douglas, prepared to desegregate.
I see it differently from Black and Douglas. You have to look at the achievements of the Negro people, the remarkable progress that's been made since the deprivations of slavery till today. I believe that in time, the states, as this progress continues, will themselves lower the barrier. Meanwhile, the Plessy decision, with its separate but equal doctrine, is the law of the land. It has been for half a century. I see no compelling reason for overturning it now.
I agree with Reed. We were not appointed to this court to make the law. We're here to interpret it. I'm comfortable with the precedents before us. Doesn't stare decisis mean that the court doesn't change its mind just because some new justice has come along?
The Chief Justice, Fred Vinson, was not ready to vote against segregation. He said that there was a solid body of precedent, like Plessy versus Ferguson, saying that segregation was constitutional because of the separate but equal principle. And he said that it was hard to get past the fact that there had been segregation for many, many years, and it was an accepted thing. So how could it suddenly be unconstitutional now? He said this court can't change something like this if the country isn't ready for it. Vinson saw segregation as being primarily a social and political problem, not a constitutional one. And he said to the other members of the court, courage is important, but so is wisdom. In other words, the court needed to be prudent and not try to do something that would be overreaching. Vincent had several others on his side, such as Tom Clark and Robert Jackson. They were like Vinson. They didn't personally favor segregation, but they weren't ready to vote to end it. There was only one person on the Supreme Court who really seemed to prefer segregation, and that was Stanley Reed. He was a Southern person from a small town in Kentucky, and he simply preferred to have racial segregation continued. He made this known to others on the court. For example, he reportedly came out of a meeting with the justices about another case where they were considering a statute that had to do with segregation of restaurants. Stanley Reed made it clear that he was shocked and appalled by the idea that a black person could be able to walk into a restaurant and sit down to eat at a table right next to him or his wife. So, there were 4 justices who wanted to affirm Plessy versus Ferguson. But there were 5 justices on the other side for striking down racial segregation of schools as being unconstitutional. Those 5 judges included Hugo Black. He was the Supreme Court justice who had been a member of the Ku Klux Klan down in Alabama. So one might have thought that he'd be sympathetic to racial segregation, but he had become a strong supporter of civil rights and liberties. And he told the other justices, "Look, I grew up in the South, and I've heard all the arguments for segregation many times. And I know they say segregation doesn't have to be a negative thing. It's just a mutually beneficial thing for everyone. But I don't need scholars or philosophers to tell me what the purpose of segregation is. The purpose is to discriminate against black people in the belief that they are inferior." And in Hugo Black's view, the 14th Amendment was adopted precisely to stop that kind of discrimination. There were several other justices who took the same position: William O. Douglas, Harold Burton, and Sherman Minton. So there were 4 on one side and 4 on the other, and the last justice was Felix Frankfurter. And he was in kind of a difficult position on this, because he was generally a strong advocate for civil rights. He had even been an advisor to the NAACP for some time before becoming a judge, and he had helped to found the American Civil Liberties Union. But he was also an advocate for judicial restraint. So normally he was reluctant to have things struck down as unconstitutional. So he had some mixed feelings about the case. He ultimately wanted segregation to be declared unconstitutional, but he wanted the reasoning of the decision to be as strong as possible. And he did not want the issue to be decided by a 5-4 vote. He wanted a more definitive, resounding declaration, because he knew this was going to be an extremely hard decision for much of the country to accept, no matter what the vote was, and he thought it would be even worse if it was decided by a single vote. So at this meeting, where the justices discussed the Brown case, Felix Frankfurter played his cards close to the vest and didn't reveal his position. He said, "Gee, I'm having a really hard time deciding this case. I'd like to get more information." He was trying to drag it out and stall so that the case would be postponed. To stall things, he started trying to come up with questions that the court could ask the parties to address and do additional briefing on. He wrote up some questions principally about the history and original understanding of the 14th Amendment, and whether the people who enacted it had thought that they would be abolishing school segregation. And he succeeded in convincing the other justices that they should have the parties do additional briefs on those issues, and then they'd have the case re-argued. Frankfurter's goal was to drag the case out so that it would be pushed over into the next term, the next year of the court's work, which would buy him more time to convince some of the dissenters to change their minds. Or at least it would provide more time to craft the best arguments to make the decision as strong as possible. So Justice Frankfurter convinced everyone to put the case off and have the parties do more work on it. Meanwhile, there are a couple of interesting little tidbits about this case that I should mention. They involved future Supreme Court justices. One is that the lawyer who argued the Brown case for the NAACP was Thurgood Marshall, and he would eventually go on to be a member of the Supreme Court.
Historians will note this hour at the White House. In a Rose Garden ceremony, a 58-year-old great-grandson of a slave is nominated by President Johnson to be a Supreme Court justice. He is Solicitor General Thurgood Marshall, acknowledged the best-known Negro lawyer of the century. The president also calls his nominee best qualified.
I have just talked to the Chief Justice and informed him that I shall send to the Senate this afternoon the nomination of Mr. Thurgood Marshall, Solicitor General, to the position of Associate Justice, Supreme Court, made vacant by the resignation of Justice Tom C. Clark of Texas.
Thus, the highest court in the land, with the vacancy owing to the stepping down of Justice Clark, has named to its august body Thurgood Marshall, the first of his race so honored.
Another one of the interesting little things that happened in the midst of all this was that Justice Jackson had a law clerk who wrote a memorandum about the segregation issue. It was entitled A Random Thought on the Segregation Cases, and it talked about how there was a time when the Supreme Court justices had made the unfortunate mistake of reading their personal economic views into the Constitution. The memo was talking about the Lochner case and liberty of contract. And this law clerk's memo said that it would be terrible if the Supreme Court justices, now in 1952, made the same mistake of reading their own social views into the Constitution by trying to end racial segregation. The memo went on to say that the NAACP's arguments in the case were clearly contrary to precedent, like Plessy v. Ferguson, and contrary to the history of the 14th Amendment, and that it would be totally illegitimate for the Supreme Court to decide that the Constitution prohibits segregation just because a majority of the court's members happen to be people who personally don't like racial segregation. The memo ended by saying, "I realize that it is an unpopular and unhumanitarian position, but I think Plessy v. Ferguson was right and should be reaffirmed." At the time, in 1952, this memorandum was not publicly available, so nobody really knew about it, and it was not a big deal. But 20 years later, it would become very controversial, because the young law clerk who wrote it was William Rehnquist. And in 1971, when he was nominated to join the Supreme Court, Newsweek magazine published the memo, and it became a big controversy. Rehnquist's opponents said that the memo represented Rehnquist's own thoughts, and that it showed that he supported racial segregation. Rehnquist's answer was that the memo was not a statement of his own opinion. He said that he was just summarizing the view of his boss, Justice Jackson. Other people who worked in Jackson's office disputed that, so there is still controversy over which of those accounts is true. Rehnquist nevertheless was confirmed and served on the Supreme Court for a long time, and eventually became the Chief Justice. Now, back to our main story. The Supreme Court has the Brown case before it, but they have postponed the decision, thanks to Felix Frankfurter's attempt to stall their work and buy more time to work on the outcome of the case. Frankfurter's stalling tactic worked out unexpectedly well, because in September of 1953, in the middle of the night, the Chief Justice, Fred Vinson, had a heart attack and died. Felix Frankfurter reportedly told someone that this is the first real indication I have ever had that there is a God. So apparently he wasn't too broken up over the death of the Chief Justice. President Dwight Eisenhower chose a new Chief Justice, and his pick was Earl Warren. Earl Warren was a very strong figure. He had never been a judge before, but he'd been the Attorney General of California, and actually he had that job during World War II, when they had carried out the internment of Japanese Americans that we read about in the Korematsu case. Earl Warren had then gone on to be the governor of California for 10 years, and he had been the Republican Party's vice presidential candidate in 1948. But he and Thomas Dewey were upset by Harry Truman in that race. So Earl Warren joined the court, and the justices heard a second round of oral arguments in the case, and then in December of 1953, they met again to take a vote.
I'm exactly where I was 1 year ago. I'm prepared to vote to desegregate. And if my vote should be in the minority, I shall write as strong a dissent as I know how.
After reading over 1,500 pages, I have yet to discover a basis in the Constitution or the 14th Amendment that allows us to order the states to do with their schools that which they do not wish to do.
Well, I was very taken by something Mr. Thurgood Marshall said. The only way the court can decide this case in opposition to our position is to find that for some reason Negroes are inferior to all other human beings.
Hugo, I base my view on the law, and nothing in the law tells us that we can tell South Carolina to abolish separate schools. This country has been making great strides in race relations. A careless decision here could halt that progress.
And Earl Warren said the time for delaying was over. He said that it seemed inescapable to him that the doctrine of separate but equal rested on concepts of racial superiority and inferiority. But he added that the crucial thing was to decide the case in a way that would produce a minimum amount of emotion and strife. He wanted the decision to be as tolerant and non-inflammatory as possible. In particular, he did not want the decision to accuse the South of having acted illegally or immorally in practicing segregation. All he wanted to say is that the practice was no longer justifiable. So by this point, there were now 6 justices ready to strike down Plessy versus Ferguson. And then it became 7, because Tom Clark gave in and switched his position. He said that he would join the majority if the relief that the court granted was carefully written in a way that would allow different handling of the problem in different places. And then Justice Robert Jackson relented as well. He said that based on the original intent of the 14th Amendment, he did not think there was actually a basis for a decision to abolish segregation. He did not think the 14th Amendment was originally meant to do that. But he was nevertheless willing to go along with eliminating segregation simply as a political or policy decision. And therefore, his only condition was that he didn't want the Supreme Court to pretend that they were merely applying legal reasoning. He wanted them to candidly admit that they were making new law for a new day. And so now, that left Justice Reed as the only holdout. He agreed with the reasoning of the court in Plessy versus Ferguson. He said that just because you have segregation, that doesn't imply that any race is superior or inferior. They're just separate. And he said there's no reason that African Americans can't achieve progress and equality while having separate schools. And so, when they voted, it was 8-1 in favor of ruling against segregation. And the majority started working on their opinions, and Justice Reed started writing his dissent. But Earl Warren did not want to have a dissenter. Not even one. And so he started taking Justice Reed out to lunch a lot over the next few months as they were working on the opinions. And he finally talked Reed out of dissenting. Earl Warren told him, "Look, I understand your views, and I agree that we've got to be very sensitive to the problems that this is going to pose in the South. But you've got to decide whether it's really the best thing for the country for us to be divided on this. Even one dissenting opinion, particularly by a justice from the South, is going to make it much harder to get people to accept this decision."
You're all by yourself now, Stanley.
The fact remains, this court has been given no evidence that the nation knew a century ago that it was outlawing separate
Stanley, we
schools.
have 8 votes to desegregate. Each of us is concerned about history. Each of us is reluctant to overrule precedents. But we are convinced that the law in this day and age cannot set Negro school children apart. Not in the United States of America.
This country has been making consistent progress in race relations. This decision could impede that progress, halt the march. A piece of paper cannot eradicate the fears and prides and prejudices of the people. Earl, if this court tries to force the southern states to change overnight, there will be resistance, litigation, disobedience, and years of conflict. Believe me.
Stanley, I'm a politician. I've worked for the people for over 30 years now. I've seen them in police stations, hospitals, unemployment lines. I'm convinced that the people will accept a ruling that fortifies their inner conscience. Let the backbone come from the court, and it'll strengthen the moral backbone of the people who live in conflict. Stanley, a fully united court will send a signal to this nation. I pray that you'll see your way clear to join the majority.
And Stanley Reed finally said that he would join the majority if they would promise that the decision and the relief that was granted would be implemented in a way that would allow segregation to be dismantled gradually, instead of in a more immediate and sudden way. And so, there was a unanimous decision in Brown versus Board of Education. And that probably helped somewhat in achieving acceptance of the decision, but obviously it was still a pretty unpopular thing for many people in many respects. The Supreme Court began its opinion in the case by talking about the historical evidence about the intent of those who wrote and voted for the 14th Amendment. And they concluded that the historical evidence, in their view, was inconclusive. And so as a result, the court couldn't base its decision on historical evidence alone. There wasn't clear historical evidence that the 14th Amendment was intended to end racial segregation. Judicial precedent was against the court as well, because the Plessy versus Ferguson case had said that separate but equal was good enough. So the Supreme Court needed to make some other sort of argument. A key argument they made was based on a footnote. It was one of the more important footnotes in Supreme Court decisions, maybe not as famous or as much analyzed as the footnote in the Caroline Products case, but nevertheless it's very well known. In the footnote in Brown, the court cited several books and articles from things like the Journal of Psychology. These were materials that talked about the latest psychological and sociological research on the effects of segregation. In particular, it cited the work of Kenneth B. Clark, who taught social psychology at the City College of New York. Clark had actually done experiments to assess the effects of segregation. For example, he'd gone out to a dime store and bought some baby dolls. They were dressed in diapers, and they were identical except that they had different color skin to represent babies of different races. Kenneth Clark also bought things like crayons and coloring books, and he used all of these things in a series of tests with children. For instance, he would show the dolls to black children between the ages of 3 and 7 years old, and first he would test their awareness of color by saying things like, "Show me the white doll," or "Show me the Negro doll." and he found that most children could correctly identify the dolls based on race. And then he would ask more subjective or emotionally loaded questions, saying things like, "Show me the doll that is the nicest," or "Show me the doll that is a good color or a bad color."
All right, Anne. Show me a white doll. Show me a colored doll. Show me the doll that has a nice color. Show me the doll that looks ugly.
And he did similar things with the crayons and coloring books. He would give a child a picture of a little boy or girl, and he would say, "Color this boy the same color that you are," or "Color this girl the color that you think little girls should be." And Clark's conclusion was that among the black children, there was a very high awareness of color and a strong preference for lighter skin color and self-rejection of their own color. The dolls and the crayons were just one example of the way that psychologists and sociologists were trying to study the effects of racial prejudice and segregation in that era. As you can imagine, it was a controversial thing. Whether this was really a solid basis for making constitutional law or not. It's interesting, certainly, if you're a psychologist or maybe even a legislator, but was it relevant to judges interpreting the Constitution? Even the NAACP's lawyers were very divided about it. Some of them thought it was a big mistake to be relying on the dolls and the crayons and that sort of research. They thought it would make it seem like they didn't really have valid legal arguments.
So, with these psychological tests, Dr. Clark, you...
Ken, please.
Well, Ken, you show that discrimination hurts the Negro children by by causing a feeling of inferiority, which impairs their ability to learn.
Oh, absolutely.
And these feelings grow into self-hatred and ultimately into despair?
No question. It starts at an early age, 4 or 5. And of course, the earlier it starts, the more permanently damaging it is.
Thurgood, Dr. Clark has been testing children for 12 years.
Well, what do you think, Bill? Gentlemen, with all due respect to the good doctor, you will be laughed out of court. Dr. Clark, you use these little dolls, don't you, in your experiment?
Mr. Coleman, my findings are consistent with and supported by a large body of research. Whatever your opinion of my methods, most experts would find merit in them.
Gentlemen, if you are going to succeed at the Supreme Court, you are going to need Mr. Justice Frankfurter on your side. Now, that is a fact. Felix Frankfurter will not buy anything that is not grounded in precedent. And if there's one thing that raises his hackles, it's the suspicion that some lawyer is running a carnival sideshow. I'm sorry, but this social science voodoo is not science, and it sure as hell isn't law.
This is not voodoo. This is about damage, real damage to real children. Thurgood, please.
Bill, you ever read the Negro Press? The Pittsburgh Courier. You ever seen Dr. Fred Palmer's ad? Be lighter. Be lovelier. Be loved. Dr. Fred Palmer's new double-strength skin whitener. Yes, sir. Does that say damage to you?
The Supreme Court did wind up citing that kind of research in the footnote in its opinion. And perhaps it was in part because they thought it was persuasive information. But more importantly, that sort of new psychological evidence was very useful because of the compromises that were made within the Supreme Court to get a unanimous opinion. Again, one of the compromises was that they weren't going to say that segregation had always been wrong and unconstitutional. They were simply going to say that now, in 1954, it's no longer acceptable. And this psychological evidence helped them frame the decision that way. As the opinion put it, whatever may have been the extent of psychological knowledge at the time of Plessy, this finding is amply supported by modern authority. In other words, they went out of their way not to put blame on anyone for anything in the past, and to talk only about the present and the future. And that helped to achieve the unanimous decision. But it also opened up the court to attacks on the ground that it was making this momentous legal decision on the basis of questionable social science research. Even some people who liked the outcome in Brown felt that this sort of research was a flimsy basis for deciding something so important. They said that social science findings like this don't always stand up very well in the long run. And what's going to happen if somebody goes out and does their own research with dolls and crayons or whatever, and comes back with compelling data for the other side? Other people argued that this stuff was just not relevant. Clarence Thomas, who was a member of the Supreme Court, is an example of this point of view. He would say it's not even relevant whether segregation caused psychological harm to children or not. It was unconstitutional regardless of that. The Constitution doesn't say you're entitled to equal protection if something is making children feel bad. It just says you're entitled to equal protection. You see another aspect of the compromises within the Supreme Court that is reflected in the last paragraph of the Brown decision, where the court acknowledges that the implementation of the case is going to be a very complex thing. It mentions the great variety of local conditions which present problems of considerable complexity. And so the court told the parties to come back again for additional argument about how to implement the decision. And that generated the Brown versus Board of Education Part 2 decision. And again, you see there the flexibility and the accommodation of varied local problems that Stanley Reed had sought in return for his agreement to join the majority and make it unanimous. And the famous phrase from this decision is at the very end, the phrase, all deliberate speed. What does that mean, all deliberate speed? When the NAACP's lawyers got this decision, they read that and actually got into an argument about whether all deliberate speed was a good thing or bad thing for their side. Because it says speed, and that sounds pretty good, like there would be changes happening soon. But on the other hand, it says deliberate speed. And someone ran to look up deliberate in the dictionary and came back and read the definition to everyone. And it said that deliberate meant unhurried, as if to avoid error. And then for a synonym, it said slow. So the Supreme Court wanted its decision to be implemented speedily and slowly, all at the same time. And in some places, it was pretty slow. In those places, there was massive resistance by private people and public officials alike. There was one part of public education that was supposed to be integrated immediately, and that was public colleges and universities. They were supposed to immediately begin admitting students of all races on an equal basis. It did not necessarily happen right away everywhere, but at least it was supposed to. So that was sort of an interesting distinction that the court made. They felt like a very different approach in terms of timing and implementation was appropriate for the college and university level as compared to the lower public schools at the elementary or secondary level. For the elementary schools and the high schools, there was an understanding that it would take some time, and it turned out to be a very long, very difficult process. And the Cooper versus Aaron case was a landmark decision that came in the midst of that. Arkansas state government authorities had simply refused to implement the Brown decision.
Segregationists swarmed the campus.
They got no business out here. This is our school, not theirs. They have their own.
The governor of Arkansas even sent National Guard units to block Central High School in Little Rock, Arkansas, so that it could not be desegregated.
I will not force my people to integrate against their will.
President Eisenhower responded by sending in federal military troops.
Such an extreme situation has been created in Little Rock. This challenge must be met, and with such measures as will preserve to the people as a whole their lawfully protected rights in a climate permitting their free and fair exercise. In the present case, the troops are there pursuant to law, solely for the purpose of preventing interference with the orders of the court.
This is Central High School, Little Rock, Arkansas. Troops, which for nearly 3 weeks lined the sidewalk here in front of the high school under orders to keep the colored students out, have been replaced now from their orders to comply with the law, which means let the Negro students in if they come in.
The Arkansas state officials, including the state's governor, basically said that the Supreme Court doesn't have the final say on what the Constitution means. And they weren't going to accept the Supreme Court's decision about racial segregation and integration. The Supreme Court in Cooper v. Aaron basically said, well, you will do what we tell you to do. The Supreme Court declared that it has, or at least it thinks it should have, the ultimate say on the meaning of the Constitution. And notice how at the beginning of the opinion, where it says who was the author of the opinion, they listed all 9 names. So they wanted to make clear that this wasn't just a unanimous decision, it was a joint effort by all 9 justices. Every one of them put their name on this to basically say, don't mess with us, we are together on this. Cooper v. Aaron very much raised an issue that had been lurking all the way since Marbury v. Madison. It was clear that the Supreme Court can interpret the Constitution. But are they the only ones who are supposed to do so? Are they the ultimate interpreters? Or do other parts or levels of government have an equal power to interpret the Constitution for their own purposes? I don't think Marbury v. Madison clearly answered that question one way or the other. It announced a doctrine of judicial review, but it doesn't necessarily go so far as to assert a theory of judicial supremacy. But here in Cooper v. Aaron, the court very unambiguously asserts the idea of judicial supremacy. They basically say that the Supreme Court is the boss when it comes to interpreting the Constitution. They say that Marbury v. Madison declared that the federal judiciary is supreme in the exposition of the Constitution, and that principle has ever since been respected by this court and the country as a permanent and indispensable feature of our constitutional system. It follows that the interpretation of the 14th Amendment enunciated by this court in the Brown case is the supreme law of the land. And Article 6 of the Constitution, the Supremacy Clause, makes it of binding effect on the states. Now, that may be exaggerating to some extent what the Marbury v. Madison opinion actually said, but nevertheless, that's the conclusion that they reach here in 1958 in Cooper v. Aaron. They say pretty clearly that the Supreme Court is the boss when it comes to interpreting the Constitution, and everybody must obey the decisions. Now, of course, Arkansas's governor probably wasn't persuaded by this opinion, but he didn't really have much of a choice at this point. He had to obey the Supreme Court. He had no choice. Why? Because the Supreme Court said so? No.
Phase 2. President Eisenhower sends 500 troops of the 101st Airborne Division of the United States Army to Little Rock by night. They are to keep order and to see that the law of the land is obeyed.
He had to comply because the U.S. Army had essentially invaded Arkansas. President Eisenhower had sent in the 101st Airborne Division. So in a way, this case illustrates something very important about the ultimate nature of constitutional law, and law in general. When you really get down to the very bottom of it all, it doesn't really matter who has the better legal position. It can come down to who has the bigger army. And Arkansas was not going to be able to prevail over the U.S. Army on this issue.
Just got a report here on this end that the students are in.
You feel it's worth it going through this?
Yes, I do.
In any event, there can be no doubt about the impact of the court's decisions about racial segregation. Brown versus Board of Education was a very dramatic step, with the court declaring that having segregated public schools violates the Equal Protection Clause. The court basically said that separate can never really be equal. Even if all the tangible things, like the teachers and textbooks and facilities, were exactly the same, the fact that the races are segregated would mean that people weren't really getting equal protection of the laws. In Cooper versus Aaron was an emphatic declaration by the Supreme Court that they were committed to the enforcement of their decision in Brown. The court had made it clear that racial segregation was no longer going to be tolerated under the Constitution, and that this decision would extend to things other than just education.